Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Patricia Cain. Patricia is a professor of law at Santa Clara University. She's been teaching law for over 37 years. She was Doogie Howser of the law profession and started teaching when she was 5 years old. No, well, anyway.
If you say so.
Anyway, she briefly practiced law before she became a professor. She's a member of the Texas and Iowa Bar and provides consulting services to law firms. She is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. Today, we are going to be talking about estate and gift tax problems of same-sex couples. Many of these problems are shared for unmarried couples, so if you don't happen to be a same-sex couple, well, first of all, everybody seems to know somebody these days, so you may be able to point them in our direction. And the other is, though, that again, unmarried couples share some of these problems. As we get started, I want to give a caution to our viewers, and that's that we're discussing issues in a very complex area. This is just a starting point for a bigger discussion, and we want you to get legal and tax advice. You must get legal and tax advice. Also, we're mostly addressing issues from federal and California standpoints. So I'm a California CPA. Patricia is teaching at University of Santa Clara, or Santa Clara University anyway, which is in California. California is a community property state. So most of the other states are not community property states. And so viewers in other states should seek advice about their local laws. And I'm just going to call Patricia Pat.
Thank you.
So, so let's get started. And thank you for joining me today.
My pleasure.
Okay. So before we get into some of the other details about this area of estate and gift tax problems for same-sex couples, let's talk a little bit about maybe some of the developments as they relate to this. What's the status of litigation for the Defense of Marriage Act? Maybe you can also explain a little bit about what the Defense of Marriage Act is about, and then how does it relate to this area of estate and gift?
Sure. The Defense of Marriage Act is a federal statute that says for federal law purposes, which of course includes tax law, only opposite-sex marriages will be treated as marriages. So anytime the Internal Revenue Code or a revenue ruling or regulation mentions spouse or marriage, it excludes same-sex spouses. Now, where this becomes most important in gift and estate tax is because of the marital deduction. A spouse can give as much as he or she wants to his or her opposite-sex spouse and pay no gift tax, no estate tax. $10 billion. Today, if I had it, or tomorrow at death. And there will be, so long as I give it to my opposite-sex spouse, there is a 100% marital deduction. This is one way, of course, that same-sex married couples or registered domestic partners are exactly the same as unmarried. In California, we do not have an estate tax and we don't have a gift tax. But at the federal level, we have both, and therefore transfers made between non-spouses are arguably subject to the, well, they are subject to the gift tax and the estate tax. Mind you, we have a $5 million exemption,
Yes.
so you don't pay any taxes until your cumulative gift giving exceeds $5 million. But we don't know how long we're going to have the $5 million exemption. It was enacted last year. We've only got it for one more year for sure. If Congress does nothing, it drops back down to $1 million.
Right.
So it's something to think about and be concerned about if you are in a couple with over $1 million and are not recognized by the IRS as spouses.
Right.
Now we have a couple of challenges to DOMA. It's going to take some time for it to get through the system. There's one before the First Circuit right now, which is probably the furthest along, but the one of most interest to the gift and estate tax issues is a case in the state of New York, which is in the Second Circuit. It's in district court now. It's being defended by the bipartisan legal advisory group, with BLAG, we call them, which is John Boehner's group out of the House of Representatives, because President Obama and Attorney General Eric Holder have said they don't believe that DOMA is constitutional, and so they don't want to defend it in court. But they do think there should be an opportunity to defend it. So Blagg is defending it, and this is the Windsor case in District Court in New York, and it involved a Canadian marriage between two women who have a lovely story, were together for, I don't know, 50 years or so, and then one of the spouses died, had a taxable estate. This was several years ago, so it was lower than $5 million. It was back when the exemption was either $1 or $2 million, and had to pay a hefty estate tax on property that was theirs, basically. I mean, it was property that they had accumulated together over their entire lifetime, but because their marriage was not recognized, they had to pay an estate tax.
Right. Now, related to this, there's a couple of things that come to my mind. So first of all, to make clear to our viewers, again, we're recording this in 2011. This $5 million exemption that Pat was talking
It's 2012, about. Michael.
It's 2012, my gosh.
Yeah, but just barely. Still
it's January. Thank you again. So it's January 24th, 2012. So anyway, this $5 million exemption was only effective for 2011, well, I guess we could say, but retroactive to 2010, yeah. Really, so 2010, 11, and 12, right?
Well, in 2010, there was no estate tax. You could elect out of the estate tax completely.
And most people would, and then they would have had the $5 million exemption for that year as well. So anyway, but the point is that after 2012, this year, this is going to supposedly go away, and we'll have to see, again, what Congress does. So, so it's not just same-sex couples that have issues or problems or questions.
Well, in the gift and estate tax field, I like to say that everyone has the same kind of problems that we in the same-sex community have been dealing with forever. We don't know what the law is or what it's going to become.
Yes, well, that part is true. The other thing is that, again, in California, we have a community property law. And so what it means is that as we earn the income, because of the efforts of one of the spouses, then both of them are considered as owning one half of whatever results.
Right. And
there's no gift, as I understand it, related to that.
This is based on an old Supreme Court opinion, the authority for this, 1930, in an income tax case, Poe versus Seaborn. But it solidified that the concept was that the federal government would recognize the state property law. This is not about state marital law. It's about property rights that a couple are given by the states that they live in. There were 8 community property states then. There are 9 community property states today. Maybe more if you count Alaska, which I'm not including in that group because it's elective. But the concept of community property is the minute it comes into existence. So if husband earns a salary of $10 million, the minute it comes into existence, it is fully vested 50% in the wife. So that there's no possibility for him to transfer the $5 million. The state vests ownership in the wife, I like to say, from the get-go, from the very minute it comes into being. You cannot tax as a gift tax unless there's a transfer of property. And under the community property scheme, there simply is no transfer.
Right. So that's sort of a key concept, and in a sense, it's an advantage for the community property states for those where we have the registered domestic partners.
This was 1930. You think about it. There was no marital deduction, well, no meaningful marital deduction at all for gift or estate tax purposes until 1948, when they decided we better give, because that's the effect. Splitting community 50-50 means that in common law states we would have to let the husband give tax-free at least 50% of his earnings to his wife. That was the rule in 1948. It became a 100% marital deduction in 1981.
Okay. Okay, so we talked a little bit about litigation on the Defense of Marriage Act. What about Proposition 8 in California? So this is, maybe you can explain a little bit of what it's about, particularly maybe we have other viewers in other places and they're wondering what's happening.
Proposition 8 was, as anybody in California in 2008 will recall, came about 7 or 8 months after the Supreme Court of California decided that the California Constitution protected the right to marry of same-sex couples. So there was what we call the window of opportunity from June of 2008 until November the 4th of 2008, when same-sex couples could legally marry in California. But then the people of California amended the Constitution by adding Proposition 8, which says a marriage shall only be between a man and a woman, meaning that constitutionally now it's impossible for same-sex couples to marry in California. It did not void the 18,000 marriages that occurred before Proposition 8 went into effect. And in fact, after November 4th, 2008, the California legislature passed Senate Bill 54, which says if you have a valid marriage entered into elsewhere, like Massachusetts or Iowa or Connecticut or any of the other states that recognize marriage, the state of California must treat you as though you were married. We'll give you all the rights and responsibilities of marriage, but we just can't call it marriage because of Prop 8. So in legal effect, really, Prop 8 has a very minor impact. It's pretty symbolic, and you can't get married in California, so it's taken away that right. And that's what's at stake in the federal litigation. That Proposition 8 is being challenged. It's valid under the California Constitution because it's in the California Constitution, right, but it's being challenged as a violation of due process under the federal Constitution of equal protection and due process, the fundamental right to marry. And so it's the trial court ruled Proposition 8 unconstitutional. It was appealed to the Ninth Circuit, but then the state of California, very much like the President of the United States, decided that they didn't want to defend it because they did think Proposition 8 was unconstitutional. And you don't want lawyers defending something they don't believe is the right legal argument. So now it's the proponents of Prop 8, the people who got it on the ballot, who defended it, they're going to step in basically as interveners to defend the constitutionality of Prop 8. It's before the Ninth Circuit, and we'll just have to wait and see what the Ninth Circuit does.
Okay. Are there any other developments before we start going through maybe some of the other details related to estate and gift that you wanted to
Not many.
discuss?
There's one that's probably worth mentioning. The IRS announced a couple of years ago a gift tax project that it had. It was asking local authorities to give them access to deeds that had been recorded between family members, not spouses, but between family members that seemed to show no consideration, that looked like they were probably a gift, but no gift tax return had been filed. Now you have to file a gift tax return if you make a gift in excess of $13,000, the amount of the annual exclusion. Did that go up this year? I
No,
don't
it's
think
still
it did.
the
It's
same.
still 13. Yes, everything else went up about $5, but this
Okay.
stayed the same. And so you should have filed a gift tax return if if a father deeds Blackacre to himself and his son as tenants in common. He's made a gift of 50% of Blackacre. If it's worth more than $13,000, he should file a gift tax return. There was a huge legal battle in California because the Board of Equalization refused to give that data to the IRS, and they won in the first round of litigation, but in the second round of litigation it's been determined that the Board of Equalization should release that information to the IRS. So this is not just about same-sex couples. This is about people who may have unintentionally made a gift, didn't realize it. You may be hearing from the IRS soon.
Okay.